My name is Chase Austin Elliott. I go by Chase or Austin. That's confusing. So a lot of people don't know what to call me, but either one will work just fine. This has been discussed a lot recently with the rise of 3D printers, and maybe some of you've seen on the internet the what they call ghost guns, where someone can print a receiver of a firearm at home. It's not serialized, it's not regulated. You know, you're going to see things like this being discussed more and more as 3D printers become more prevalent, and the ability to make these type of handguns or rifles at home, you know, becomes a more widespread thing. The Gun-Free School Zones Act, I'm sure everyone has seen a sign like this at schools. This is just a federal law that prohibits unauthorized individuals from having a firearm on school grounds or a certain distance away from those school grounds. The Brady Handgun Violent Protection Act, the Brady Bill, as I said earlier, this was a significant one. This is Jim Brady, who was shot in the assassination attempt of Ronald Reagan, and that was the start of what became the Brady Handgun Act, which was signed in 1993 by Bill Clinton. This required background checks for the sale of firearms, and it further shored up prohibitions on illegal possession of firearms by what we will call later prohibited persons. Federal assault weapons ban, this is something that's been talked a lot about in the last 3 or 4 years. It existed from 1994 to 2004. It sunset in 2004 when the Congress did not renew it. And it prohibited what they call assault-style weapons with a detachable magazine or a pistol grip, and their, you know, bayonet lug, and there's certain other types of requirements that would classify a particular rifle as an assault rifle or assault weapon. And the Protection of Lawful Commerce in Arms Act, 2005. This was to limit civil liability for firearms manufacturers. It treated firearms manufacturers like almost any other products liability cases. As long as they didn't have knowledge, or you couldn't, with a preponderance of evidence, show that they had knowledge that these firearms they were manufacturing were solely for the use of criminal activity or primarily for the use of criminal activity, there wouldn't be any civil liability for the manufacturer. It didn't include things like the gun blowing up and hurting you or anything like that. It was just about weapons being used in crimes and third parties being injured from those weapons. All right, we're going to discuss primarily today the National Firearms Act, NFA, the Gun Control Act, GCA, FOPA, and the Brady Bill. And starting with the National Firearms Act, the first significant federal regulation of firearms in the history of our country. Grant talked about this earlier, but the flamboyant bank robbers of the 1920s and early 30s and their tactics really gave rise to the National Firearms Act and it eventually being passed. But you're thinking, you know, sawed-off shotguns, Tommy guns, things like that. You know, everyone's seen the classic image of someone with the fedora on carrying the Tommy gun underneath the trench coat. I think that's probably the Dick Tracy cover, actually. But it was passed in 1934, and it was really intended, despite what all of the legislative history says, on curbing violence that was associated with organized crime. The federal government used its authority to tax to follow through with these regulations, and it created a registration requirement of certain types of firearms, which I'll go over in just a minute. They had to be registered with the Secretary of the Treasury, and as I said earlier, it really regulated the transfer, whether it be from two parties or from a manufacturer to a buyer, and there had to be a tax paid for each of those transfers, and otherwise it would be prohibited by this act. The National Firearms Act regulates what we refer to as machine guns, generally speaking, short barrel rifles, silencers or suppressors, which are used almost interchangeably, and short barrel shotguns or sawed-off shotguns. They also regulate what are called any other weapon. You know, you can see all kinds of crazy stuff, like the cane here that's a gun, or you know, there's a knife that's a gun, or a pen gun, or a gun that fits in your wallet. It regulates destructive devices. It's pretty straightforward. Explosives, artillery, things like that. Grant went into this, and I'll go into it a little bit further, but the St. Valentine's Day Massacre is the most widely, I guess, known incident that people associate with the National Firearms Act. Al Capone and his gang, Al Capone was in Florida at the time, but his cohorts dressed up as police officers lined up 7 members of a rival gang against a wall and shot them, gunned them down with at least 2 Tommy guns. There's a picture of the aftermath. Over 70 rounds were fired. It was in 1929. And Al Capone was never charged for it, but it's basically accepted now that he ordered this hit. Interestingly, one of the Tommy guns used was purchased initially by a sheriff's department in Michigan. And the Tommy gun is in a way most associated with the National Firearms Act because it's a weapon of choice for gangsters, and widely used in Hollywood. You got even Winston Churchill there in the Second World War with a Tommy gun. And I actually got 2 pictures of Tom Hanks, one as a gangster and one as a soldier using a Tommy gun. And of course the Home Alone, keep the change, you filthy animal. As I said earlier, basically the National Firearms Act mandated that a tax be paid for every transfer of one of these items regulated by the Act. And it was $200 then, and it's $200 now. $200 was intended to be cost prohibitive at the time. I did a little research on the Consumer Price Index, and $200 in 1934, when the Act was passed, is the equivalent of about $3,600 today, or as of 2016.
Why have they not raised it? Or would it kind of disclose their real purpose in the Act is not that?
Politics. I'll go into this in a minute. The National Firearms Act still exists. It's been updated, recodified, and modified with the Gun Control Act in 1968, the FOPA in 1986, but that $200 has always remained there. The definitions of the different items regulated in the National Firearms Act has remained roughly the same, even though it may be moved in different places in the federal code. But I guess that never had the votes to raise the tax. It's not, I guess it's tongue-in-cheek that it's supposed to be cost prohibitive. It's not, you're not going to find that written down anywhere, but clearly it was. They picked $200 for a reason when this was first enacted in 1934, and there's not many things I can think of that haven't increased in price since 1934. So take that for what it's worth. In 1968, the Supreme Court, Haynes versus United States, found that the registration requirements of the original National Firearms Act were unconstitutional because the Department of the Treasury could notify a defendant's home state, if they're being prosecuted there, that the particular firearm that may or may not have been used in a crime was either on the registered list or not on the registered list. And the Supreme Court found that that violated protections guaranteed by the Fifth Amendment and it rendered the NFA unconstitutional and unenforceable at that time. Coincidentally, we got the Gun Control Act of 1968, same year. The Gun Control Act was really the result of the high-profile assassinations in the 60s. JFK, of course, Robert Kennedy, Martin Luther King. Lee Harvey Oswald actually purchased the rifle that was used in the Kennedy assassination, or one of the rifles, depending on how much of a tinfoil hat you have on. But he purchased that on a mail-order catalog. So up till this time, with the Gun Control Act, you could buy guns in the Sears catalog or in any other periodical and just send off your check, and then a certain amount of time later, you'd get a gun in the mail. So this really created the political climate necessary, these assassinations, to enact new legislation. And Title I of the Gun Control Act is what we refer to Title I firearms, regulates, we'll call them conventional firearms, and it regulates firearms dealers, manufacturers, and it defines what we'll later call prohibited persons, or what kind of actions or classifications make a private citizen prohibited from possessing a firearm. And then Title II of the Gun Control Act is a recodification of the National Firearms Act of 1934, and it remedied certain unconstitutional provisions found by the Haynes decision, and moved the National Firearms Act to a different section of the federal law, and it's actually cross-referenced in the IRS code because the IRS and the Department of the Treasury handle the $200 tax stamp. A couple of, just the intentions of the Gun Control Act. They wanted to stop blind sales, meaning firearms from this point forward had to be done if you were in the business of selling firearms in a gun store by a federally licensed gun dealer. It limited the sale of firearms, particularly handguns, to the state. The state they were being purchased. That person purchasing the item had to be a resident of that state for handguns. As I said earlier, it created the outline of what makes a person prohibited from possessing a firearm. It changed the licensing requirements and regulation of firearms dealers. And it also, and this is important for FOPA in just a second, limited the importation of certain types of what they call weapons of war. Destructive devices are included in that, machine guns. You had people coming back from World War II in Korea with Nazi machine guns, items from Korea, grenades, things like that. So you couldn't import any of these things post 1968 with the Gun Control Act. The Secretary of Treasury regulated the National Firearms Act in 1934, and they had that authority through the Gun Control Act. They delegated these duties in the Gun Control Act to the Bureau of Alcohol, Tobacco, and Firearms, and now they call it Anti-Explosive. The ATF and the BATF, BATFE were born, and they handle the regulation on dealers and firearms trafficking, serious firearms crimes like that. Lower level stuff has always been prosecuted on a state level, or as Grant said earlier, with drug conspiracies and people that are prohibited on a 922G charge, as we'll talk about in a second. FOPA, it got started, or I guess gained steam after the Reagan assassination, but it was initially, I guess, talked about whenever a Senate subcommittee was doing a report on the Second Amendment, and they found that the ATF, and this would have been in the early 1980s, they found that since 1968, the ATF were really pressing ordinary citizens and dealers that had no intention of breaking the law, but because of ignorance or non-sophistication, were actually in violation of the Gun Control Act of 1968. And this was by and large the way that that law was being enforced and prosecuted. They put certain safeguards in this act for the dealers, for individuals, but what it's most known for now is its prohibition on machine guns. So post-1986 and FOPA, there are essentially 3 classifications of machine guns. The first class is the fully transferable pre-1986 registered machine guns. That pre-registration means that it was registered anytime up until May of 1986, pursuant to the federal law at that time. There are 175,000 of these in existence. They are the only type of machine gun that can be possessed by a citizen legally. Because of the finite number and the fact that there aren't any more being made or classified in this way, they have an extreme value that regulates a lot like any other commodity. But for example, a Vietnam-era M16 could go for as much as $25,000. And people would really just be after the receiver on that weapon because that's what's regulated as a firearm and then therefore registered by its serial number with the ATF and can be owned by a citizen. The Tommy guns sometimes go for as much as $40,000. So these can be possessed legally. You don't see a ton of them in the hands of private citizens because they are so expensive. There are many gun ranges that possess these and will allow people to rent and shoot them, but typically not transferable weapons. They have what's called dealer samples that they actually rent out to people to use at the range that day. A second classification, these are just machine guns that were registered from 1968 in the Gun Control Act until 1986. Now that's significant because post-1968 you couldn't import any machine guns as a weapon of war, so they would have to be all domestically produced machine guns that were also registered with the ATF prior to May 1986 when FOPA was enacted. There's only about 17,000 of these in existence, and they cannot be possessed by citizens, only dealers. And then the post-1986 dealer sample, this is what I was referring to when I was talking about gun ranges that rent these machine guns out for people just to use. They can only be possessed by dealers while the dealers have their license in effect. They also can only be procured by that dealer when they have what's called a law enforcement letter. Now that's a letter from any local law enforcement saying that that agency is considering buying an H&K MP5 or whatever it may be, but it has to specifically ask for whatever type of firearm they want to demonstrate or look at. And once you have that letter, a dealer can go directly to the manufacturer, have a new item made, and then possess that, show it to law enforcement, and then keep it afterwards, provided they maintain their license, the dealer. Going into the 90s, the Brady Bill, enacted in 1993, said earlier, it's named for James Brady, who was shot by John Hinckley, in the Reagan assassination attempt in 1991. It requires background checks. Initially, it had a mandated 5-day wait period, which was lifted in 1998 with the the implementation of the NICS system, which was originally when the dealer would call in to the FBI NICS system, have the FBI run the background check, and then get a green light or red light from them before they could transfer that firearm. It's done online and over the phone now. The Brady Bill also enacted what our current law is as regards to what is a prohibited person. Prohibited person generally is a felon, a person with a misdemeanor conviction of domestic violence. That doesn't have to be a felony. Certain other types of misdemeanors that could be the term of imprisonment could be more than 2 years, could also make you prohibited. You can't be an unlawful user or addicted to controlled substances. What a lot of people don't know is that even a misdemeanor simple possession of marijuana ticket, not even an arrest, can make you a prohibited person if the FBI has knowledge of it, if the local state or county reported that ticket to the FBI. Their interpretation of that law is that the person can't say they are not an unlawful user of a controlled substance if they have a simple possession of marijuana charge pending. If you've been adjudicated mentally defective, that's like an involuntary commitment, or you had a guardianship placed over you, things like that. That has not been widely conveyed on a state level to the federal government, which is the reason we had the Alan Bowling case, which hits close to home here, because South Carolina, up until a couple of years ago, didn't report any kind of an involuntary commitment to the federal government, the NICS system. Right, and practically speaking, that's only ever, hardly anyone would ever check yes on that box. But like I said earlier, if even if you have a pending misdemeanor for, like I said, simple possession, that can make you a prohibited person. It's going to trigger a flag in the FBI NICS system, and
But I'm not talking about charges. I'm talking about use. I'm thinking about states like California with
right.
legalized recreational marijuana. Is that what?
So that's been a topic of debate or concern among people that do what I do. As far as the separation of powers and supremacy and all that, the federal government, if the FBI NICS has any knowledge that you're using, they'll deny you. What the individual puts down on their what's called an ATF 4473 form, the form they fill out to buy the gun, that's going to be up to them. Now, how would this ever come up? Well, I could imagine some facts where in California or Colorado, someone picks up some kind of federal charge, and the government or the prosecution has some kind of evidence that they also use use anything that's prohibited on a federal sense, and maybe tack on a 922G charge or something like that. I don't think that's probably ever done because they don't ever need that leverage. But the way that I read the law, and based on what I know about it, both as a lawyer and a gun dealer, I think that if you're using something that's prohibited under federal law but legal under state law, this still prohibits you. The unlawful user means unlawful under federal law.
You mentioned a form.
Right. So
that form filled out under a penalty of perjury, or
it is, and it's Exhibit A in a 922G charge. It's called the ATF 4473. It's a standardized form that is used in every gun store in America. The person buying the gun has to fill it out for themselves, which is obviously why it's Exhibit A a lot of times on a straw purchase sense. But you have to put down all of your information, name, address, date of birth, social, and you fill out a questionnaire regarding these particular items, basically to determine whether or not you're a prohibited person. There are cases out there where is it knowingly or unknowingly? I believe the standard is knowingly withhold information or outright lie on this, but it says on there in italics, under penalty of perjury. Restraining orders for persons, what they call intimate partners or parents, child, things like that. If those are on record, or if you have knowledge of it, you're prohibited. Typically, the NICS wouldn't have any knowledge of that, but if the individual buyer does, they should check yes, they are under a restraining order, and therefore the gun dealer would be on notice that they can't sell that gun to them.
What if the gun dealer knows of his own knowledge, his or her own knowledge?
Well, then the gun dealer would be subjecting themselves to federal prosecution for knowingly transferring a person who was a prohibited person. The Alan Bolin case that I mentioned earlier, that was a gun store in Orangeburg, and Alan Bolin had a 2005 involuntary commitment. She was charged for threatening to kill President George W. Bush. The solicitor's office, I believe, referred the matter, or they dismissed the case because she was involuntarily committed, as she should have been. Because they dismissed the case, because she was committed, there was no conviction. Now, there was a state record of her involuntary commitment, but that was never reported from SLED to the FBI. So years later, when she goes to Orangeburg to buy a gun, she, of course, lies on her form, breaking the law, but whatever. But that gun dealer had no knowledge, and the FBI NICS had no knowledge that she had this prohibition, and they sold her the gun. She tried to shoot the person, the teacher at Ashley Hall. The gun didn't go off because she didn't load it properly, and disaster was avoided, but it caused us to change the law in South Carolina and require those involuntarily commitment and guardianship proceedings to be reported directly to SLED and the FBI to prevent something like this from happening. And most states have that requirement. We just didn't hear it at the time. These are the separate requirements. I'll go through them real quick. Felon, obviously, would be a prohibited person, a fugitive. The substance abuse we just talked about, the mental adjudication. An illegal alien can't possess or lawfully buy a firearm. It'll be interesting to see over the next several years how new immigration policy affects this part of the law. A dishonorable discharge from the military if they've renounced their citizenship. Like I said earlier, the restraining order, the domestic violence, all of those things will prohibit a person from lawfully possessing a firearm. Title I firearms. If you recall, Title I firearms refer to the Title I of the Gun Control Act regarding conventional firearms. It defines what a firearm is in general. Handguns, conventional rifles, meaning they have a barrel longer than 16 inches, and an overall length of more than 26 inches. Shotguns have barrels longer than 18 inches, and an overall length greater than 26 inches. Those are Title I firearms. These are what are sold in any gun store. The vast majority of people that own any type of firearm own one of these types. This is just the code section. This is in your material, so I'll skip through it. Handguns, obviously, are regulated on a much tighter basis. There are minimum age requirements for handguns of 21 versus 18 for rifles, so there's a distinction there. Handguns can only be sold, as I said earlier, to a resident of the same state as the dealer they're buying the handgun from. But a person from another state can buy a rifle or shotgun, sometimes referred to as long guns, from a dealer in another state if that rifle or shotgun is lawful in their home state. Shotguns. Antique firearms, anything prior to 1898 is not considered a firearm and therefore not regulated under 922G. So you can go into an antique store or anything like that and buy a firearm without any kind of further regulation if it was made prior to 1898.
Did you say that, maybe I heard you wrong, did you say that when someone purchased across the state lines to go purchase a weapon, and that weapon is perfectly legal in the state in which they purchased it, but the state in which the person lives, it is prohibited? You're saying the firearms dealer can prevent them from purchasing that particular weapon simply because of where their driver's license is or where their residence is?
Yes. This happens frequently. The best example of this are places that are states that surround other states that have like an assault weapons prohibition or something like that. I'm told, and I've done, I think I've sold 600 or 700 guns in my short career selling guns, and I've never seen it come up, but I'm told that the FBI NICS has a process in place where you have to give, when you call it in or put it in online, you have to put in their home state. And their state of residence is generally their driver's license, a couple of exceptions for soldiers and things like that, and then you use their orders. but by and large, it's the driver's license. So when you put in the driver's license, that's their state of residence, and you know, if you're trying to sell a firearm that is prohibited in their state and the dealer knows about it, the onus is on the dealer to prevent that transaction. But you know, the FBI and the FBI NICS system is only really aware of it being either a shotgun rifle or a handgun.
How does that limitation interface with the concealed weapon reciprocity issue? So if you've got a gun that's perfectly legal in your state, you travel to, say, Virginia, it's not legal there, but everything else is fine. How does that interact?
Well, a concealed weapons permit, from a dealer's perspective, that allows the dealer to not run the NICS check. If you have a valid concealed weapons permit, you put that down in addition to the driver's license, and you don't have to run it through the NICS system. Now, a dealer would still be prohibited from selling a handgun to a person from another state. That doesn't change. You know, if a person from South Carolina goes to Virginia and wants to buy a rifle or a shotgun, they have the CWP, that dealer in Virginia. And again, it's the prerogative of the dealer. They can not run the NICS check, or they can. I mean, I guess, you know, a dealer may get nervous if it looks fake because they're not used to what another state's CWP looks like, or, you know, wouldn't be aware if it is outright, you know, fraudulent. But you can't buy a handgun in any other state other than the one you're a resident of, no matter what.
With the concealed weapon, though, you can carry.
Sure, if there's reciprocity, you can carry. Mm-hmm.
In a state that weapon is particularly prohibited, then I guess you're subject to the unlawful carrying of a pistol or...
In that particular state, you would be, because you know, those types of law regulate possession.
Sure. Thank you.
Quickly, curios and relics. Any item that's over 50 any firearm that's over 50 years old and has any kind of historical value or collectible appeal, it is still regulated as a firearm, but it's classified as a curio and relic, and it will allow citizens to get what's called a CNR license for them to possess these type of curios and relics and acquire them without the normal procedures that an individual would have to go through, meaning they wouldn't have to go to a gun dealer to buy these things. They could show their federally issued QNR or CNR license and just, you know, buy a gun from another dealer, just like they were a regular firearms dealer. But it has to be a firearm that's classified as a CNR. Just quickly, there's no national registry of firearms. There's no state registry of firearms. I'm talking about regular Title I firearms. A lot of people, I guess, don't believe this. They think that when you do the background check at a dealer, that creates some kind of registry. But that was a major point of contention with the Brady bill, that the FBI NICS system had to discharge their records. I think it's after 30 days, maybe 90 days. Now, whether they do that or not, I don't know. I'm sure you could find plenty of message boards and websites that would say that they are unlawfully keeping these items, which would say, you know, John Doe at number 1 Broad Street purchased a handgun on February 1st, 2016. In theory, those records do exist for a certain amount of time, but the law does require the FBI to discharge and not keep any record of that. Any kind of background check only identifies the person and the type of firearm they're buying. It doesn't identify the serial number associated with the firearm they're buying. There's no federal concealed weapons permit. It's done on a state-by-state basis. Yeah, the age requirement's 21 years and older for handguns to buy them from dealers, 18 years or older to buy rifles and shotguns from dealers. These are the different items that make you prohibited. We went over those earlier. The current law for FFL dealers, like myself, they have to proceed with every transaction on an ATF 4473 form, and that makes a record of the pertinent information of the person buying the firearm. That ATF 4473 form, and I mean it's a paper form, will have the make, model, and serial number of the particular firearm they're buying, and then there will be what's called an NTN number, which is given by the FBI for the transaction. Now, that transaction, meaning the background check, doesn't have any record of the serial number or make or model of the firearm on the FBI level, but that's maintained in the paper form by the dealer. There are strict requirements for record keeping for this type of forms, and if the dealer ever goes out of business, they have to pack all these up in a box and ship them to the ATF processing branch in West Virginia, who store them, I suppose. And it's however many thousands of 4473 forms, which would represent every single transaction that gun dealers had over however long they've been in business. Sales between private parties, they're not heavily regulated by the federal government. Federal law mainly applies to FFL dealers, but FFL dealers are outright prohibited from selling any long gun to a person under the age of 18, but an unlicensed person, a private citizen, can sell any type of firearm, or any type of long gun, excuse me, to a person of any age, provided it isn't unlawful in that person's state. But that's not regulated on a federal level, unlicensed people. South Carolina law, it doesn't prohibit in the statute anybody under 18 from buying a handgun from a private person. It prohibits a private person from selling a handgun to someone under the age of 18. So that's, it creates a don't ask, don't tell situation for private sales. I haven't ever seen this prosecuted in this way. I would suspect it is not done very often. And that kind of leads us into private parties and gun show purchases. I'll quickly go through that before I get into the Title II stuff. What people call the gun show loophole, what they mean by that is just the lack of federal regulation on the sale of firearms between private parties. I guess the gun show loophole comes from the sense that gun shows attract a lot of people and provide the marketplace for a private person walking around with their own personal firearm to sell it to any other person that happens to be walking around the gun show at the same time. So that's why it's called the gun show loophole, but really it's just a lack of regulation from the federal government on any private person selling to someone else. Now, the law does say that in a private sale, the seller can't have any actual knowledge that the buyer is a prohibited person. So you can imagine the facts where you have an undercover ATF agent going up to a private person saying, hey, I want to buy this, but I'm a felon. Will you still sell it to me? They sell it to them. They've got them because that person was put on notice that the buyer was prohibited. Oh. All right, we'll go.
You got time for a question on that?
Sure, go back.
So not so much what I often see, because I just do civil laws, I often see interfamily transfers that aren't purchases, it's just grandpa dies, and all the guns go to the grandson. Is it what governs that? Do you have to register them? How do you get them from grandpa to grandson? What covers that?
The answer is probably nothing. Now, of course, state law would apply to that. What you're referring to is it's just a private, it's like a private transaction. Transaction. I mean, it doesn't have to be a sale, in the sense that any money's changing hands, but that's still a private transaction, okay. And it's not prohibited, with the caveat that there are prohibitions on giving it to someone that is prohibited. One of the ways that we said you could be a prohibited person earlier, or if the person is under 18 years old for a handgun. So that's the only federal prohibition for possession of like a non-licensee sale, meaning if you're under 18, federal law says that you can't possess a handgun. Now, we have a CJA case right now where you have a father and a son both indicted. The son is under the age of 18. It's debatable whether or not that son is prohibited from one of the other easy reasons, but they're prosecuting it right now as an unlawful possession of a firearm because the son is under 18. So that's the only time I've ever seen it used in that way. But the situation you're talking about happens all the time. No one, knows whose gun it was or when it was ever purchased, if it was lawfully purchased originally. All of those scenarios are kind of rolled into what is referred to as the gun show loophole. Now, anytime you get into a political debate about closing the gun show loophole, what people are most likely referring to, and I mean legislators, are requiring all transactions of all firearms to go through a dealer, someone like me. We have that ability to do it. You could come in with the lady sitting next to you to my law office and say, hey, I want to sell her this gun. We've agreed on a price privately. I know there's no prohibition on me selling this gun to her, just whatever, but I want to be safe. So I can facilitate the transaction, run her background just like I would if she was buying the gun from me in that capacity, and that could be done. So that's not required. It can be done by dealers. And if they ever close the gun show loophole, it will be something like the situation you're referring to where every transaction has to go through a dealer. The obvious problems with that are inheriting guns, buying guns for a son or a father or a daughter or whatever. So those are the hurdles, and that's usually why it's a non-starter, the debate. Online sales. Online sales are 100% legal. You hear this referred to on TV a lot, and it drives me crazy because you almost think that they're saying that you could get on Amazon and buy a gun and have it shipped to your house. That's not the case. When you buy a gun online, you pick it out, pay for it. The financial part of it's irrelevant. But whenever the transaction part is done, that gun has to be shipped to a local FFL dealer for the actual transaction, which is the background check. So that's how online sales truly work. Now, sometimes you have situations like Craigslist or whatever where you're talking about almost like a virtual private party sale where the buyer and seller find each other just online. But that's already prohibited across state lines, but there's no prohibition on starting a conversation, meeting on a place to go sell this gun, provided you are a resident of the same state.
But then there's no proper procedure in that case. There's no procedure at all.
Right, and that's what that's the gun show loophole. But there's just no prohibition on it. So, if you and I are Facebook messaging and say I want to sell this gun to you, are you 21? Yes. Are you a felon or a prohibited person? No. All right. Well, I'll meet you at the Walmart parking lot and sell it to you. There's a site called Arms List where this happens all the time or frequently. Guns America is like that. There's a site called Gun Broker, which is almost exactly like eBay but for firearms. I would say by and large, those transactions on Gun Broker are facilitated through a FFL. I do those all the time. So you haggle with the person on price and shipping. They take it to their dealer, ships it to your dealer, and then I would finish out the transaction. So that's how it should be done. It's not always done that way. Okay, we'll quickly go into, let me jump slides here. Title II firearms, also known as NFA firearms, also known as Class III. Class III is the most widespread way that these items are referred to. If you recall, Title II firearms are machine guns, silencers, suppressors, short barrel rifles, meaning the barrel is less than 16 inches, or short barrel shotguns, barrel being less than 18 inches. There's the any other weapon thing and destructive devices, but those are so rare that I don't think it's pertinent to tell you about them right now because it's almost never seen. The misnomer. Class III firearms or Class III weapons is the biggest misnomer I can think of as it relates to firearms. I think it's so widespread among laypersons that myself and other dealers, even though they know the distinction, will still refer to them as Class III firearms, even though that's really a totally inaccurate way to describe Title II firearms. Class III refers to the tax classification. for the dealer, me. Since I am a federal firearms dealer, I can choose to pay an extra tax. It's $500 every single year, which gives me the authority to deal in these Title II firearms. Dealers are classified as Class 3. They pay $500 extra a year. That's where the Class 3 comes from. I don't know where this started, but anytime you hear people refer to Title II weapons or firearms, they almost always say Class 3. So just know that those are synonymous, even though that Class 3 is the misnomer. Class 1, those are for importers. You don't hear anyone say Class 1 because no private person ever deals really with an importer. Class 2 are manufacturers, and then Class 3, dealers, like I was just saying. The various types: short barrel shotgun, short barrel rifle, suppressor, machine gun. We've already gone through most of this stuff. And just quickly, this is sometimes what people refer to as a AOW, any other weapon. Now, over the last couple of years, these what looked like a rifle without a buttstock have become very popular, and I guess the layperson has wondered why. Well, this gun here on top is classified as a pistol, even though it looks like a rifle. Why is it classified as a pistol? Well, if it's classified as a pistol and it doesn't have a buttstock, it's not regulated by Title II. It's regulated by Title I. Any dealer can possess it and sell it to any private person without all of the extra procedure that's needed for regular Title II firearms. But if you get that pistol up there and you fasten a buttstock to it, or if you put a foregrip on it, like this fourth picture here, you've illegally manufactured a Title II NFA firearm just by adding that foregrip on there, because you're now using that item as a rifle. It happens to be a short barrel rifle, and you're breaking federal law. So these distinctions are pretty minute. I don't know how often they're truly prosecuted. In fact, the top pistol up there, there are dozens and dozens of manufacturers that make something like that. And they also sell what they call an arm brace that looks just like a buttstock, but it's designed to be placed around your arm with the intention of holding that pistol out with one arm and shooting it. But you know, if you wanted to use that device improperly, you could put that arm brace against your shoulder, and then you have a pistol that you can use as a short barrel rifle and avoid all of the procedural hoops to jump through to get the Title II item.
And the ATF actually has issued a letter stating that it's not a use of an NFA
Yep.
firearm. You take that gun as perfectly legal without changing it one bit, but if you hold it and it touches your shoulder, you manufacture it.
Sure, and you know, I think it's the hypothetical of them having you know, a picture of an individual using one of these pistols with a arm brace, putting it up against their shoulder. Picture of that, I think, is sufficient for prosecution, you know, on a 922G charge. So,
Prosecution of manufacturing, right?
well, no, because it's being used in it's an unintended use. So that goes back to FOPA, right?
But the letter actually said that's manufactured by its very use.
I know the letter you're referring to, and that's been a topic of debate among people in the industry. I don't know if it's ever been done yet, but it's talked about. No one really knows how it you know, shakes out, because no one can point to a specific case yet. But that ATF letter exists, and prior to that, an ATF opinion letter existed that, you know, if an individual used that arm brace in an unintentional way, that it was fine. So it goes back and forth.
They weren't changing the manufacturer.
Right.
Their original stance.
Right. So that's, you know, that's significant. All these little distinctions are significant because it's how they define firearms, how long's the barrel, what are the features of it. A firearm itself is, for rifles and shotguns, the firearm is just the receiver. It's not the barrel. You could order any type of barrel or bolt or anything like that directly to your house. They're not regulated items. But the receiver, the main part of the chassis, essentially, of the gun, is the firearm. So, you know, there are people that sell receivers, but they don't have the last 10% of the work done to them, and those aren't regulated. They sell them right through the mail to people, and the end user can drill the holes and build the gun, and order the barrels and bolts and all the other parts of the gun and manufacture it themselves. And, you know, they most likely haven't violated federal law if there's no state prohibition and they haven't made it into a Title II item, meaning a short barrel rifle or a short barrel shotgun. But,
If I could ask a question. Sorry, I don't
Yeah,
know
sure.
a lot about this law, that's why. When they make these differentiations between the different firearms, if I could call them that, do they make it on the basis simply of what they look like, or do they make them on the basis of the power that they have, the ability to kill lots of things? Or is it literally just I can see this and it looks like that?
yes, kind of. It's the features. And there's very specific language referring to the length, overall length, the way that the receiver is set up. Does it have a detachable magazine? Does it have what's called a pistol grip here? Or is it just a regular stock? During the 1990s assault weapons ban, manufacturers could get around those provisions by removing the button for the magazine and the pistol grip here. And they would just incorporate a thumb hole into the buttstock. So it didn't have a pistol grip, and you know, they eliminated certain features or made workarounds to stay ahead of the law. And you know, it was just the language. It's I guess to really specifically answer your question, it's not just I look at it and like it looks like one. No, you have to, you know, torture the language of how it's actually regulated when it describes the features and the make and model and layout of the gun.
I guess that was actually the function of it. How it functions is not how it's classified.
The only function that's regulated, to my knowledge, is if it auto repeats, meaning it's a machine gun.
Okay.
So that would you know, if you can pull the trigger, hold it down once, and it fires multiple times, then it falls into how a machine gun's classified. We're about out of time, so I'll give like 3 minutes here on the procedures for Title II firearms. Title II firearms, like we were just talking about, can be possessed by citizens, but the procedures are pretty intense as far as getting to that. We talked earlier about the $200 tax stamp. You have to file a certain form, which is dependent on what type of Title II firearm you're trying to buy. There's a form for each one, and you file that. You send off your $200 check to the ATF, and they take about 6 or 7 months to approve it. Now, they get fingerprints from you. They get a passport-style photo from you, and that's sent in. Used to, you had to have what's called Chief Law Enforcement Officer permission, which was an outright roadblock in some places where your chief of police or your sheriff wouldn't sign off on it. You just couldn't have it, that NFA or Title II item in that area. That gave rise to the NFA Trust. You've probably heard people talk a lot about them. Trusts or corporations or LLCs could possess these Title II items, and the trust was the party that was applying for the item and paying the $200 tax stamp. So no one was ever fingerprinted, no one was ever photographed in those scenarios. That's why they were so popular. You also avoided the Chief Law Enforcement Officer signature, meaning you didn't have to have permission. That was recently gutted in July of last year. NFA trusts are still used. They're still valuable because you can have multiple people with one tax stamp. But every single person that is allowed to possess the NFA item in that trust has to become what's called a responsible party, and they all have to submit fingerprints, photographs in the application to get these items. There have not been, I've done a lot of these recently since the law has changed. It's taken 7 or 8 months, so I haven't seen one come back yet with the stamp under the new law. So you're going to see a lot of people that have old NFA trusts that don't really describe who is a responsible party in that trust. Generally, it's the trustees, beneficiaries, and settlor of the trust. But we don't know yet. We don't know how stringently they're going to look at the trust and who's what. But any person, if you have a client that wants to talk about NFA trust or they want to show you an old one and they're seeking advice, you certainly want to tell them that any beneficiary, trustee, or person setting up the trust is most likely a responsible party, and they're going to be subjected to all of the requirements, just like you were if you were getting it as an individual. You can draft language to take the beneficiaries out. If you have language that doesn't allow the beneficiaries to possess or use the NFA property, then under the law they wouldn't be considered a responsible party, and maybe you can avoid the fingerprints and the photographs for them. But no one really knows yet because we're still too close to the law change. We haven't seen how they've been dealt with. That's a crash course on the NFA process. It's very arduous, so feel free to ever call or email if you have a client with questions about it. Does anyone have any questions?
Back to this estate and the passing down of weapons. Can a regular old lawyer like me call? Can we do checks? For example, we get grandpa dies and we have to deal with an estate, and there's all kinds of weapons, and they're not all historic weapons, and they're not even all over 50 years old. And we now are passing this estate on to someone. As a lawyer, can I call in and check on who I'm passing the guns on to through the estate, so I don't end up in a suit for
Right.
giving the guns to somebody who shouldn't have them?
You cannot call, an individual cannot, lawyer or otherwise, cannot call into the NICS and run a check. You have to give them your license number, and it has to be set up. So they don't provide that for private parties. I've had probate lawyers come to me for the exact scenario you're talking about, and I'll do it for them in that sense. But again, you would only do that out of an abundance of caution, or maybe you just want to be careful.
That's why we do it.
Sure. But it's not often done, especially in unrepresented probate cases, because there's no prohibition on it, right? As long as it's not one of these Title II NFA items, if it's just a regular firearm, there's no prohibition on the transfer. It's just treated like a private sale. If the beneficiaries or the inheriting parties aren't prohibited. Now, I've got to believe that there are probate cases out there where property's getting passed down to people that are prohibited, and I don't think the probate court's checking. I don't think anyone's checking. So, the court is essentially facilitating an unlawful transfer of a firearm, but no one's the wiser, I suppose. And I guess that's the whole point of all of this. In a way, there are not many regulations on firearms, but the laws that we do have are written very, very distinctly and very specifically. And I would say there's not a ton of exceptions, meaning there's a lot of leeway on getting around them. I mean, that's the takeaway, in my opinion, of someone who deals with this.
I don't think there's any, executor liability in doing that, but I think from a state planning standpoint, I know my whole partner would actually ask you, do you have any, if anything, any personal property broken, including NFA weapons, do you have any items outside of firearms that require any licensing that's specific to you, because not the executor, but the individual who acquires an NFA weapon through an estate is now legally in possession of it.
Correct. I mean, that's certainly best practice, and I suppose you could try to draft language to...
And if you own one, you're putting your heirs in jeopardy of violating the NFA.
And there's a specific form, it's an ATF Form 5, which you never hear about, that's used for the transfers that are through operation of law for the inheriting procedure, and there's no tax requirement. They don't have to pay the $200 tax stamp. You have to pay the $200 tax stamp for any transaction, not just the first one. Every time that gun is moved or NFA item is moved, you pay the $200 tax stamp, and it's for each item. It's not like you pay once and and then you can buy as many suppressors or short barrel rifles as you want. You do it for each individual item, and that's how it's been done since the 30s. Anyone else? All right. Well, thank you very much.